The day Brenda Patterson showed up at my door with her clipboard and fake smile, I knew my peaceful life in Maplewood Estates was about to get complicated. I'm Gregory Jennings, and I had just spent the last 3 weeks preparing my property for the arrival of a 20-foot storage container. My garage was packed to the ceiling with tools, seasonal decorations, and all the equipment I needed to run my small contracting business. The storage container was the perfect solution, or so I thought. I had done everything by the book. I hired a structural engineer, got the proper permits from the city, and even had a concrete foundation poured to ensure everything was stable and up to code. The container arrived on a Tuesday morning. The delivery went smoothly, and by noon, it was sitting exactly where I wanted it, on the eastern side of my property, precisely 18 feet from the property line, well within the legal setback requirements. The foundation was perfect, level, and solid. I stood back, admiring my handiwork, feeling satisfied that I had solved my storage problem in the most professional way possible. That satisfaction lasted exactly 48 hours. Brenda showed up on Thursday afternoon, her heels clicking against my driveway like a death march. She was wearing a cream-colored pantsuit that probably cost more than my monthly mortgage payment, and her bleached blonde hair was pulled back so tight it looked painful. Her expression was the kind of fake friendly that immediately sets your teeth on edge. "Mr. Jennings," she said, her voice dripping with false sweetness. "I'm here on behalf of the Maplewood Estates Homeowners Association. We need to discuss your recent property modification." I wiped my hands on my jeans and walked over to meet her. "You mean the storage container?" "I've got all the permits. Everything's completely legal." Her smile never wavered, but her eyes got colder. "Be that as it may, the container violates our community guidelines. Specifically, Section 14, subsection C, which states that no external storage structures may be visible from the street or neighboring properties." I gestured toward the container. "You can barely see it from the street. It's behind my fence line and tucked between 2 oak trees. Plus, I checked the guidelines before I had it installed. There's nothing in there about storage containers." Brenda pulled out a thick binder from her designer bag. "The guidelines refer to any structure used for storage purposes. The HOA board has reviewed your situation, and we've issued you a formal violation notice. You have 14 days to remove the container or you'll face daily fines of $200. My jaw dropped. $200 a day? That's insane. I spent $5,000 on the foundation alone. You can't just demand I remove it because you don't like how it looks. I'm afraid we can, Mr. Jennings. You agreed to abide by HOA regulations when you purchased your home. The notice is effective immediately." She handed me an official-looking letter with the HOA seal at the top. I took the letter, my hand shaking slightly with anger. "This is ridiculous. I'll fight this." Brenda's smile finally cracked a little, revealing something harder underneath. "That's certainly your right. The next HOA board meeting is in 3 weeks. You're welcome to present your case then. Good day, Mr. Jennings." She turned on her heel and walked back to her silver Mercedes, leaving me standing in my driveway holding a violation notice that felt like it was burning a hole through my hand. I immediately called my friend Marcus, who had lived in Maplewood Estates for 10 years. He answered on the second ring. "Marcus, it's Greg. The HOA just hit me with a violation notice over my storage container." There was a long pause on the other end. "Oh man, is it Brenda Patterson handling it?" "Yeah. How did you know?" Marcus sighed. "She's the new HOA president. Took over about 6 months ago and has been on a warpath ever since. She fined the Hendersons for having their garbage cans visible from the street for more than 2 hours after pickup." made the Johnsons repaint their entire house because the shade of beige they chose wasn't on the approved color list. And don't even get me started on what she did to old Mr. Chen about his garden gnomes. This is unbelievable. I have all my permits. Everything's legal. Doesn't matter to Brenda. She thinks she's protecting property values, but really, she just likes having power over people. You're going to need a lawyer, Greg. A good one. I spent the rest of that evening researching HOA law and reading through every single page of the Maplewood Estates guidelines. Marcus was right. There was nothing specific about storage containers. The section Brenda referenced was vague and could be interpreted multiple ways. But that vagueness could also work against me. The next morning, I called Robert Chen, the structural engineer who had designed and certified my foundation. He was a quiet man in his late 50s with decades of experience in residential and commercial construction. "Mr. Jennings," he said when I explained the situation, "I've seen this kind of thing before. HOAs often overstep their authority when it comes to structures that have proper engineering documentation. The foundation I designed for your container meets or exceeds all state and local building codes. It's rated for wind loads up to 120 miles per hour and can handle soil settlement over a 50-year period. That container isn't going anywhere. Can you provide me with documentation of that?" "Absolutely. I'll email you the full engineering report today. You should also know that your container setup is actually safer than many permanent structures I've evaluated in your neighborhood. The foundation has proper drainage, reinforced concrete with rebar, and anchoring points that meet FEMA guidelines for severe weather." This was exactly what I needed. I thanked Robert and started putting together my case. I printed out all the permits, the engineering report, photographs of the installation process, and highlighted sections of the HOA guidelines that supported my position. 3 days after receiving the violation notice, I received a second letter from the HOA. This one informed me that the fines would begin in 11 days, and that failure to comply would result in legal action, including potential liens against my property. I couldn't eat. I couldn't sleep. The stress was affecting my work, and I started losing clients because I was too distracted to give them proper estimates. My girlfriend, Sarah, tried to be supportive, but even she was starting to worry about the financial implications. "Greg, maybe you should just move the container," she suggested one evening as we sat on my back deck. "It's not worth the fight." "It's not about the container anymore," I said, staring at the structure that had become the center of my life. "It's about the principle. I did everything right. I followed every rule, and now they're trying to bully me into submission because one person doesn't like how it looks." Sarah reached over and squeezed my hand. "Then fight it, but be smart about it." The next morning, I hired an attorney. His name was David Morrison, and he specialized in property law and HOA disputes. His office was in downtown Richmond, Virginia, about 30 minutes from Maplewood Estates. David was in his early 40s, sharp-dressed, and had a reputation for not backing down from fights. "I've reviewed your case," David said during our first meeting. "And honestly, Mr. Jennings, you have a strong position. Your container is on a proper foundation, you have all necessary permits, and the HOA guidelines don't explicitly prohibit what you've done. The problem is that HOAs have broad authority in Virginia, and sometimes courts side with them on aesthetic matters, even when the homeowner has done nothing technically wrong. So what are my options?" David leaned back in his chair. "We can fight this in several ways. First, we request a hearing with the HOA board before the fines take effect. We present your case with the engineering documentation and permits. If they still rule against you, we can take it to mediation. If that fails, we might end up in court. But I'll be honest with you, litigation is expensive and time-consuming. Most HOA disputes take 12 to 18 months to resolve. And in the meantime, they can fine me $200 a day. They can try. But once we file a formal legal response, they typically can't enforce fines until the matter is resolved. However, that doesn't stop them from being difficult in other ways. I authorized David to send a formal response to the HOA, requesting a special hearing and providing all my documentation. The letter went out that afternoon via certified mail. 2 days later, I got a call from Brenda Patterson herself. "Mr. Jennings, I received your attorney's letter. I must say, I'm disappointed that you've chosen to escalate this matter. I'm disappointed that the HOA is trying to fine me for something that's completely legal and properly engineered." I shot back. Her voice got colder. "The board has agreed to hear your case at a special meeting next Tuesday at 7 p.m. Be prepared to present your documentation. I should warn you, however, that the board has already conducted a preliminary review, and the consensus is not in your favor. Then why bother with the meeting? Because due process matters, Mr. Jennings, even when the outcome is inevitable." She hung up before I could respond. The weekend before the meeting was torture. I rehearsed what I would say, organized my documents into neat folders, and even practiced my presentation with Sarah playing the role of a hostile board member. By Monday night, I felt as prepared as I could be. Tuesday evening arrived with an unexpected thunderstorm. Rain poured down as I drove to the community center where the meeting would be held. David Morrison met me in the parking lot, both of us running through the rain with our briefcases held over our heads. The community center was a modest building at the entrance to Maplewood Estates. Inside, a conference room had been set up with a long table at the front where 5 board members sat. Brenda Patterson was in the center, flanked by 2 women and 2 men, all looking equally serious and stern. About 15 other residents were scattered in chairs around the room. I recognized some of my neighbors, including Marcus, who gave me an encouraging nod. Brenda called the meeting to order with a sharp rap of her gavel. "We're here to address the violation notice issued to Mr. Gregory Jennings regarding an unauthorized storage structure. Mr. Jennings, you have 30 minutes to present your case." David and I walked to the front of the room. I set up my presentation materials on an easel while David addressed the board. "Thank you for hearing this matter. As you'll see from our documentation, Mr. Jennings has gone above and beyond what's required by law to ensure his storage container is safe, legal, and appropriately placed. We have permits from the city, a full engineering report certifying the foundation, and photographic evidence showing that the container is minimally visible from public areas." I began my presentation, walking through each document. I explained how I'd researched the placement, hired a licensed engineer, and obtained all necessary permits. I showed photographs taken from various angles on the street, demonstrating that the container was barely noticeable unless you were specifically looking for it. Robert Chen, the engineer, had agreed to attend as a witness. He stood up and addressed the board directly. "I've been a structural engineer for 32 years. I've worked on everything from residential homes to commercial high-rises. The foundation supporting Mr. Jennings's container is engineered to standards that exceed what's required for many permanent structures. It has proper drainage to prevent water accumulation, reinforced concrete rated for heavy loads, and anchoring systems designed to withstand extreme weather conditions. From an engineering perspective, this is a model installation." When we finished, Brenda looked unimpressed. "Thank you for your presentation. However, the engineering specifications are not the issue here. The issue is visual impact and community standards. One of the other board members, a man named Thomas Ridley, spoke up. I drove by Mr. Jennings's property yesterday. I had to actively look for the container to even see it. It's tucked behind his fence and partially obscured by trees. I'm not sure I understand the problem. Brenda shot him a sharp look. The problem is precedent, Thomas. If we allow one storage container, we'll have them popping up throughout the community. Before you know it, Maplewood Estates will look like an industrial park. But the guidelines don't prohibit storage containers, Thomas pointed out. They mention storage structures, but that's different. A container on a proper foundation is more like a shed or a workshop. Another board member, a woman named Patricia Hughes, chimed in. I have to agree with Thomas. If Mr. Jennings has all his permits and the structure is safe, I'm not sure we have grounds to force its removal. Brenda's face was turning red. Section 14, subsection C is clear. No external storage structures visible from the street or neighboring properties. David stood up again. With respect, Mrs. Patterson, that section has been interpreted very loosely over the years. There are at least 6 properties in this community with visible sheds and 3 with detached workshops. None of those homeowners have been cited for violations. That's different, Brenda snapped. Those structures are aesthetically appropriate. Appropriate by what standard? David pressed. You're applying a subjective aesthetic judgment to enforce a vaguely worded guideline against one homeowner while ignoring similar situations throughout the community. That's selective enforcement, and it won't hold up in court. The room went silent. Brenda's jaw tightened, and for a moment I thought she might actually explode. Instead, she forced a tight smile. The board will deliberate and provide Mr. Jennings with our decision within 5 business days. This meeting is adjourned. As people filed out, several neighbors came up to shake my hand and wish me luck. Marcus clapped me on the shoulder. You did great, man. I think you actually might have them. But David was more cautious. Don't celebrate yet. Brenda Patterson doesn't strike me as someone who accepts defeat gracefully. He was right to be worried. The decision letter arrived exactly 5 business days later. The board had voted 3-2 in favor of upholding the violation. I had 10 days to remove the container or the fines would begin. The 2 dissenting votes were Thomas Ridley and Patricia Hughes, but they had been outvoted by Brenda and the other 2 board members. David called me as soon as I contacted him about the letter. This is what I expected. Now we escalate. I'm filing for mediation through the Virginia Department of Professional and Occupational Regulation. They handle HOA disputes and can issue binding decisions. How long will that take? Usually 60 to 90 days to get a hearing. In the meantime, I'll file an injunction to prevent the fines from taking effect. The injunction was filed the next day, but it took another week for a judge to review it. During that time, the 10-day deadline passed, and the HOA began assessing fines. $200 a day started adding up fast. By the time the injunction was granted, I had accumulated theoretical fines of $2,800. The injunction stopped any further fines from accruing, but it didn't erase the ones already assessed. David assured me that if we won the mediation, those fines would be voided, but the stress was taking its toll. I lost 10 pounds, started having trouble sleeping, and my relationship with Sarah was strained to the breaking point. Then things got worse. About 3 weeks after the board's decision, I came home from work to find a notice taped to my front door. It wasn't from the HOA. It was from the City of Richmond Code Enforcement Division. Someone had filed a complaint about my storage container, claiming it was an unpermitted structure. I called the number on the notice immediately. A bored-sounding woman answered and pulled up my case file. "Yes, Mr. Jennings. We received an anonymous complaint about an unpermitted storage structure at your address. An inspector will be coming out next week to evaluate." "But I have all my permits," I protested. "Everything was done legally. If that's the case, you have nothing to worry about. Just have your documentation ready for the inspector." I knew exactly who had filed that complaint. Brenda Patterson was escalating the war. The inspector arrived the following Tuesday. His name was James Martin, a middle-aged man with a tired expression and a tablet computer. I met him in the driveway and walked him around to where the container sat. "I've got all my permits right here," I said, handing him a folder with copies of everything. James reviewed the documents, cross-referencing them with something on his tablet. Then he walked around the container, taking measurements and photographs. He spent extra time examining the foundation, kneeling down to check the drainage and looking at the anchor points. After 20 minutes, he stood up and brushed off his pants. "Mr. Jennings, your permits are all in order. The foundation meets code requirements and the container placement is within legal setback limits. I'm going to close this complaint as unfounded." Relief washed over me. "Thank you." James hesitated, then lowered his voice. "Off the record, I've been doing this job for 15 years. I can usually tell when someone's being harassed. Your setup is better than most permanent structures I inspect. Whoever filed that complaint was wasting everyone's time." He left, and I immediately called David to update him. He wasn't surprised. It's a common tactic. If they can't get you through the HOA, they try to use city code enforcement to create problems. At least that backfired on them. The mediation hearing was scheduled for late October, 3 months after the initial violation notice. Those months were brutal. Brenda found new ways to make my life difficult. She had the HOA attorney send threatening letters every 2 weeks, reminding me of the accumulated fines, and suggesting that they would place a lien on my property if the dispute wasn't resolved in their favor. She also started targeting other aspects of my property. I received violation notices for having my garbage cans visible for 3 hours after pickup, for having a small oil stain on my driveway, and for letting my grass grow a 1/4 inch over the maximum allowed height. Each violation came with threats of additional fines. David advised me to document everything. I took photographs with timestamps, kept copies of every letter, and even started recording my interactions with Brenda when she would drive by my house slowly, clearly checking for any possible violations. Sarah finally had enough and moved out in September. We didn't officially break up, but she said she needed space until the situation was resolved. I couldn't blame her. The stress had made me irritable and obsessed. I was spending every free moment working on my case instead of living my life. The mediation hearing finally arrived on October 28th. It was held at a state office building in Richmond. The mediator was a retired judge named Alina Foster, a woman in her 70s with sharp eyes and a no-nonsense demeanor. The hearing room was set up with tables on opposite sides. I sat with David Morrison. Across from us were Brenda Patterson and the HOA's attorney, a slick-looking man named Kenneth Wright. Judge Foster began by outlining the mediation process. "This is not a trial. I'm here to facilitate a resolution between both parties. I've reviewed all the submitted documentation, including the engineering report, permits, photographs, and HOA guidelines. Let's start with the HOA presenting their position." Kenneth Wright stood up, launching into a rehearsed speech about community standards, property values, and the importance of aesthetic consistency. He argued that storage containers were industrial equipment and had no place in a residential community, regardless of permits or engineering specifications. The guidelines give the HOA broad authority to maintain the character of Maplewood Estates, he said. Mr. Jennings's container, while perhaps technically legal from a building code perspective, violates the spirit of those guidelines. The board acted within its authority to protect all homeowners. When it was our turn, David systematically dismantled their arguments. He pointed out that the guidelines didn't mention storage containers at all, that the HOA had allowed similar structures for other homeowners without complaint, and that selective enforcement was a violation of Virginia HOA law. Furthermore, David continued, the engineering report proves that Mr. Jennings's container is safer and more structurally sound than many permanent structures in the community. The city has confirmed all permits are in order. The HOA is attempting to impose aesthetic preferences that aren't supported by their own guidelines and are being enforced selectively against my client. He then presented evidence of the selective enforcement. We had photographs of 6 other properties with visible storage structures, including 2 that were far more visible from the street than my container. None of those homeowners had received violation notices. Judge Foster asked pointed questions of both sides. She seemed particularly interested in the selective enforcement issue. Mrs. Patterson, she said, addressing Brenda directly, can you explain why these other structures haven't been cited for violations? Brenda shifted uncomfortably. Those structures are different. They're traditional sheds or workshops that fit the aesthetic of the community. But the guidelines don't distinguish between traditional sheds and other storage structures, do they? The board has always had discretion to interpret the guidelines as needed. Discretion is one thing. Arbitrary enforcement is another. Judge Foster made a note on her legal pad. Let's take a 15-minute recess. I'd like both parties to consider what a reasonable compromise might look like. During the recess, David and I discussed our options. I think she's leaning in our direction, he said quietly. But mediators typically want both sides to feel like they got something. Be prepared to offer a concession, even a small one. Like what? Maybe you agree to add some landscaping to further screen the container. Something cosmetic that doesn't cost you much but gives them a win. When we reconvened, Judge Foster addressed both parties. I'm prepared to issue my findings. However, I'd like to give you both one more opportunity to reach a settlement. Kenneth Wright and Brenda huddled together for a whispered conversation. Then Kenneth stood up. The HOA would be willing to withdraw the violation if Mr. Jennings agrees to relocate the container to a less visible location on his property. There is no less visible location, I said. It's already in the most concealed spot possible without violating setback requirements. David added, my client has spent over $5,000 on the foundation alone. Relocating would require building a second foundation at additional significant expense. That's not a reasonable compromise. Judge Foster nodded. I agree. Mr. Wright, do you have any other proposals? Brenda leaned over and whispered furiously to Kenneth. He shook his head several times, but she kept insisting. Finally, he spoke again, clearly reluctant. The HOA requires that the container be painted to match Mr. Jennings's house, and that additional landscaping be installed to further screen it from view. David looked at me. I considered it. Painting the container and adding some shrubs would cost maybe $1,000, far less than continuing this fight. I can agree to that, I said. But the fines have to be completely voided, and the HOA has to update their guidelines to clearly address storage containers so this doesn't happen to someone else. Kenneth and Brenda conferred again. This time, The whispered conversation lasted several minutes and became increasingly heated. I could see Brenda's face getting red, her hands making sharp, angry gestures. Finally, Kenneth turned back to us. The HOA agrees to void the fines and will consider updating the guidelines at a future date. Not good enough, David said. The guidelines must be updated within 90 days, with specific language that either permits or prohibits storage containers with clear criteria. No more vague language that can be selectively enforced. Judge Foster intervened. That seems reasonable, Mrs. Patterson. Updating your guidelines to provide clarity for all homeowners is simply good governance. Surely you can agree to that. Brenda looked like she had swallowed something bitter, but she nodded stiffly. Fine. We'll update the guidelines. Judge Foster wrote up the settlement agreement on the spot. Both sides signed it. The fines were voided. I agreed to paint the container and add landscaping within 60 days, and the HOA agreed to update their guidelines within 90 days to provide clear standards for storage structures. As we left the building, I felt like a massive weight had been lifted off my shoulders. David shook my hand. You did good, Greg. Most people fold when the HOA comes after them. You stood your ground. I couldn't have done it without you. Send me photos when you get the container painted. I'm curious to see how it turns out. I drove home feeling lighter than I had in months. The settlement wasn't perfect, but it was fair. I had won the important battles, keeping my container and forcing the HOA to operate more transparently. That weekend, I went to Home Depot and bought paint that matched my house, a soft gray-blue color. I also picked out several fast-growing shrubs that would provide additional screening. The next Saturday, Marcus came over to help me paint. I can't believe you actually won, he said as we rolled the first coat of paint onto the container. Nobody beats Brenda Patterson. I didn't beat her. The facts beat her. She was enforcing rules that didn't exist. Still, she's going to hold a grudge. Watch your back. Marcus was right to worry. Over the next few weeks, I noticed Brenda driving by my house more frequently. She never stopped or said anything, but the slow roll-by became a daily occurrence. It was creepy and intimidating, but I documented each instance with date and time stamps, just in case. The container looked great once it was painted and the landscaping was in. You really couldn't see it from the street anymore unless you knew exactly where to look. Several neighbors commented on how nice it looked and asked about the process I'd gone through. Apparently, word had spread throughout Maplewood Estates about my battle with the HOA. A few other homeowners reached out to me, sharing their own stories of Brenda's overreach. The Hendersons told me about the garbage can incident that Marcus had mentioned. The Johnsons showed me the paint color chart they'd been forced to choose from when repainting their house, which included exactly 4 shades of beige and nothing else. But the most disturbing story came from Tom Chen, whose father had been forced to remove his garden gnomes. Tom invited me over for coffee one afternoon in late November. My father had those gnomes for 20 years, Tom said. They were a gift from my mother before she passed away. He has Alzheimer's now, and those gnomes were one of the few things he still recognized. Brenda made him remove them because they violated some aesthetic guideline. Dad got so upset he had a medical episode. Spent 3 days in the hospital. That's awful. Did you fight it? We tried, but Dad's condition deteriorated and fighting the HOA was just too much stress. He's in a memory care facility now. I sold his house last month. Tom's eyes were watery. I know it sounds silly getting emotional about garden gnomes, but they represented something important to him, and she took them away just because she could. This conversation haunted me. My situation had worked out, but how many other people had been hurt by Brenda's arbitrary enforcement of vague rules? The HOA was supposed to protect property values and maintain the community, not terrorize residents. I decided to do something about it. The 90-day deadline for updating the HOA guidelines was approaching. I started attending the monthly HOA board meetings to monitor the process. At the first meeting, Brenda tried to rush through the updated guidelines with minimal discussion. The new language was barely better than before, still vague and subject to interpretation. I stood up during the public comment period. "Excuse me, but these updated guidelines don't meet the spirit of our settlement agreement. They're still too vague. Storage containers should be explicitly addressed with clear criteria for size, placement, and foundation requirements." Brenda's eyes narrowed. "Mr. Jennings, the board has fulfilled its obligation to update the guidelines. The specific language is at our discretion." "Actually," David Morrison's voice came from the back of the room. I turned to see my attorney had shown up, uninvited but very welcome. "The mediation agreement requires that the guidelines provide clear standards. What you've drafted here is just as vague as before." Judge Foster specifically ordered clarity to prevent future selective enforcement. Several other homeowners in the audience murmured in agreement. Thomas Ridley, the board member who had sided with me before, spoke up. "David's right. We need to be more specific. Otherwise, we're just setting ourselves up for more disputes." Patricia Hughes agreed. "I move that we table this vote and create a subcommittee to draft more detailed guidelines. We should also get input from residents." The motion passed 3-2, with Brenda and her two allies voting against it. After the meeting, several residents approached me, thanking me for speaking up. A woman named Linda Torres asked if I'd be willing to serve on the guidelines subcommittee. "I'm not a board member," I said. "You don't have to be. Community members can volunteer. And honestly, you know more about this than any of us." I agreed, partly because I wanted to ensure the guidelines were fair, and partly because I was curious to see how deep Brenda's dysfunction ran. The subcommittee held its first meeting 2 weeks later. It consisted of Thomas Ridley as the board representative, Linda Torres, myself, and 2 other homeowners, Frank Martinez and Susan Young. We met at the community center and spent 3 hours drafting comprehensive guidelines for storage structures. The new guidelines specified that storage containers were permitted if they met certain criteria: proper foundation, appropriate setback distances, reasonable efforts at screening from public view, and size limitations. We also included language about sheds, workshops, and other structures, with clear standards that applied equally to all. Most importantly, we included a provision that any violation enforcement had to be applied consistently across the community. No more selective targeting of homeowners the board didn't like. We presented our draft at the next board meeting. Brenda looked like she had bitten into a lemon as Thomas read through our proposals. When he finished, she immediately launched into objections. "These guidelines are too permissive. They'll open the door to all kinds of unsightly structures." "They're clear and fair," Thomas countered, "which is exactly what we need. I move we adopt these guidelines as drafted." Patricia seconded the motion. The vote was 3 in favor, 2 against. Brenda and her 2 allies were outvoted again. As people filed out after the meeting, Brenda cornered me in the parking lot. Her fake friendliness was completely gone now, replaced by pure venom. "You think you're very clever, don't you, Mr. Jennings? Coming in here, disrupting how we've always done things, turning board members against me." "I'm just trying to make sure the rules are fair for everyone," I said calmly, though my heart was pounding. "Fair," she practically spat the word. "I've dedicated 5 years to this community. I've protected property values and maintained standards, and you've undermined everything in a matter of months. Maybe if you'd applied the rules fairly in the first place, none of this would have been necessary." Her face went bright red. "You haven't won, Mr. Jennings." "I'll make sure of that." She stormed off to her Mercedes and peeled out of the parking lot, tires squealing. David Morrison, who had witnessed the exchange from his car, walked over. "That sounded like a threat." "It did, didn't it? Document everything, Greg." Women like Brenda Patterson don't make idle threats. I went home that night feeling uneasy. I had won the battle over my storage container and helped create fairer guidelines for the community, but I had also made a powerful enemy. The question was, what would Brenda do next? The answer came 2 weeks later, just before Christmas. I received a certified letter from a law firm I didn't recognize. Inside was a lawsuit. Brenda Patterson was suing me personally for harassment, defamation, and intentional infliction of emotional distress. She claimed that my actions during the HOA dispute had caused her severe emotional trauma and damaged her reputation in the community. She was seeking $50,000 in damages. I stared at the lawsuit in disbelief. This was insane. I called David Morrison immediately, even though it was 8 p.m. on a Friday night. "I was expecting something like this," David said when I read him the complaint. "It's called a SLAP suit, strategic lawsuit against public participation. She's trying to intimidate you and punish you for standing up to her. The good news is that Virginia has anti-SLAP laws. We can get this dismissed pretty quickly and possibly get you attorney's fees." "How quickly is quickly?" "Couple of months." "Don't worry, Greg. This lawsuit is baseless. No judge is going to let it proceed." Despite David's reassurances, being sued was terrifying. I had to file a formal response, which cost more legal fees. The lawsuit also had to be disclosed to my insurance company, which made them nervous even though it was clearly frivolous. Worse, Brenda started spreading rumors around the community. I heard through Marcus that she was telling people I had threatened her, that I was unstable, and that I was trying to destroy the HOA from within. None of it was true, but mud sticks. Some neighbors who had been friendly before started avoiding me. The preliminary hearing on David's motion to dismiss was scheduled for February. In the meantime, I tried to live my life normally, but the stress was overwhelming. I was being sued for standing up for my rights. It felt like punishment for refusing to be bullied. Then something unexpected happened. In mid-January, I received a phone call from Susan Young, one of the members of the Guidelines Subcommittee. She sounded nervous. "Greg, I need to talk to you about something sensitive." "Can you meet me for coffee?" We met at a Starbucks in downtown Richmond. Susan looked around nervously before pulling out a manila folder. "I've been doing some digging into the HOA finances," she said quietly. "I'm an accountant, and something hasn't sat right with me for a while. The HOA dues have been going up every year, but we're not seeing improvements in the community. So I requested financial records, which I'm allowed to do as a homeowner." She opened the folder and showed me spreadsheets covered in highlighter marks. "There are discrepancies, Greg. Big ones. Money that's supposed to be in the reserve fund isn't there. Expenses that don't make sense. And a lot of payments to a property management company that I can't find any record of." "What are you saying?" "I think Brenda has been embezzling from the HOA, possibly for years. We're talking about potentially $100,000 or more." My jaw dropped. "Are you sure?" "Not completely, but sure enough to be concerned. I wanted to tell you first because, well, you're the only person who's successfully stood up to her. I'm afraid if I take this to the board, she'll find a way to bury it. We need to involve the police." "Do we have enough evidence for that?" I thought about it. "Let me talk to David. He'll know what to do." I called David from my car after leaving Starbucks. He listened carefully as I explained what Susan had found. "This changes everything," he said. "If there's financial fraud, that's a criminal matter. But Susan's right that we need to be careful. We can't accuse Brenda without solid evidence, or she could sue for defamation and actually have a case. We need a forensic accountant to review the records. Can you arrange that? I know someone, but it's going to cost money." "How much?" "Probably $5,000 for a preliminary audit, maybe more if it's complicated." I didn't have that kind of money lying around, but I couldn't let this go. If Brenda had been stealing from the community, she needed to be held accountable. Plus, if we could prove she was corrupt, it would destroy her lawsuit against me. I talked to Susan, Marcus, Linda Torres, and a few other homeowners who had been victims of Brenda's overreach. We pooled our money and hired a forensic accountant named Rachel Simmons. Rachel reviewed the HOA financial records over the next month. What she found was damning. Brenda Patterson has been systematically embezzling from the HOA for at least 4 years, Rachel explained during a meeting at David's office. She created a fake property management company and has been billing the HOA for services that were never rendered. She's also inflated expense reports and pocketed the difference. My conservative estimate is that she's stolen $137,000. "Oh my God," Susan whispered. "Can you prove it?" David asked. "Absolutely. I have bank records showing the payments to the fake company, and I've traced the money to personal accounts in Brenda's name. I also found emails where she discussed the scheme with someone, possibly a family member. This is solid evidence of wire fraud and embezzlement." David leaned back in his chair. "Then it's time to go to the police." We filed a report with the Richmond Police Department the next day. Detective Maria Santos was assigned to the case. She was a sharp woman in her late 30s who specialized in financial crimes. "HOA embezzlement is more common than you'd think," she told us. "Board members have access to funds with minimal oversight, and a lot of homeowners don't pay attention to the finances. It's an easy target for someone who's inclined to steal." The police investigation moved faster than I expected. Within 2 weeks, they had obtained search warrants and seized Brenda's financial records and computers. The evidence Rachel had found was confirmed and expanded. Brenda had been even more brazen than we'd realized, using HOA money to pay for personal vacations, a new car, and even home renovations. Brenda Patterson was arrested on March 15th. I wasn't there, but Marcus was driving by when the police showed up at her house. He said she was led out in handcuffs, screaming that she was being persecuted and that we had all conspired against her. The local news picked up the story. "HOA president arrested for embezzlement" became a headline in the Richmond Times-Dispatch. The story detailed how Brenda had stolen over $140,000 from Maplewood Estates residents and used her position to intimidate anyone who questioned her authority. My phone rang off the hook with reporters wanting interviews. I declined most of them, but I did speak to one journalist who had covered HOA issues before. I wanted to make sure people understood that this wasn't just about stolen money. It was about abuse of power and the need for accountability in HOA governance. Brenda's lawsuit against me was quietly withdrawn 2 days after her arrest. Her attorney sent a 1-sentence letter discontinuing the case without explanation. David filed a motion for sanctions and attorney's fees based on the frivolous nature of the suit. The judge granted it, ordering Brenda to pay $15,000 to cover my legal costs. Of course, collecting that money would be difficult since Brenda was now facing serious criminal charges and would likely have to pay restitution to the HOA. But the principle mattered. She had tried to intimidate me with a bogus lawsuit, and it had backfired spectacularly. The HOA board held an emergency meeting to address the crisis. Brenda was immediately removed as president and kicked off the board. Thomas Ridley was elected as the new president. One of his first acts was to apologize to everyone who had been unfairly targeted by Brenda's enforcement actions. "We're going to do better," Thomas said at the meeting. "The new guidelines are in place, and we're committed to fair and transparent governance. What happened with Brenda Patterson was a betrayal of trust, and we're taking steps to ensure it never happens again." The community rallied together in a way I hadn't seen before. There was a sense that we had collectively dodged a bullet and needed to rebuild trust. Several new homeowners volunteered to serve on the board, bringing fresh perspectives and energy. As for me, life slowly returned to normal. My storage container sat on its engineered foundation, painted gray-blue and screened by landscaping. It held all my tools and equipment, exactly as I had intended when I installed it nearly a year earlier. Sarah and I reconnected in April. She had heard about Brenda's arrest and reached out to congratulate me. We met for dinner, and she admitted she had been following the case from afar. "I'm sorry I bailed on you," she said. "The stress was too much for me, but I should have been more supportive." "It was too much for me too," I admitted. "I became obsessed. I get why you needed space." We agreed to take things slowly, but it felt good to have her back in my life. The months of fighting had taken a toll on both of us, but we were both willing to try again. Brenda Patterson's criminal case proceeded through the courts over the next several months. Her attorney tried to negotiate a plea deal, but the prosecutor wasn't interested in being lenient. The evidence was overwhelming, and the amount stolen was substantial. The trial was held in August. I attended several days of testimony, watching as prosecutors laid out the full extent of Brenda's fraud. She had been stealing from the HOA for nearly 5 years, starting small and getting bolder as no one questioned her. She had used the money to maintain a lifestyle she couldn't afford on her actual income. The jury deliberated for less than 4 hours before returning guilty verdicts on all counts: embezzlement, wire fraud, and filing false financial documents. The judge sentenced her to 6 years in federal prison and ordered her to pay full restitution of $142,000 to the HOA. As Brenda was led out of the courtroom, she looked smaller somehow, diminished. The power and authority she had wielded so ruthlessly were gone. She was just a middle-aged woman who had made terrible choices and would now pay the consequences. I didn't feel triumphant watching her being taken away. Mostly, I felt sad that it had come to this. If she had just followed the rules fairly, if she had treated homeowners with respect instead of using her position to bully people, none of this would have happened. Her downfall was entirely self-inflicted. The HOA used the restitution money to replenish the reserve fund and make long overdue repairs to community facilities. The entrance sign was refurbished, the community center got a new roof, and they even installed a new playground that residents had been requesting for years. Thomas Ridley proved to be an excellent HOA president. He was fair, transparent, and actually listened to homeowners. Under his leadership, the board adopted new financial oversight procedures to prevent future embezzlement. They also created an ombudsman position to handle disputes before they escalated to legal action. The updated storage structure guidelines worked well. 3 other homeowners installed storage containers over the next year, all following the clear criteria we had established. There were no disputes because everyone knew exactly what was allowed. As for me, I tried to return to a normal life. My contracting business picked up again once I wasn't consumed with fighting the HOA. Sarah and I moved in together in October, finding a nice apartment while I rented out my house in Maplewood Estates. I couldn't live there anymore. Too many memories of the battle. But I kept ownership because property values had actually increased after Brenda's removal. The community was healthier and happier without her reign of terror. I did keep the storage container, though. New tenants appreciated having the extra storage space, and it served as a reminder of an important lesson. Sometimes you have to stand up to bullies, even when it's hard, even when it costs you, because doing the right thing matters. Looking back on the whole experience, I'm struck by how a simple storage container became the catalyst for uncovering serious corruption. If Brenda hadn't targeted me over something so trivial, if I had just removed the container rather than fighting back, she might have continued stealing from the community for years longer. Sometimes standing up for yourself is about more than just your immediate situation. It's about exposing injustice and creating accountability. My fight over a storage container ended up protecting an entire community from a corrupt leader. Marcus likes to joke that I'm a HOA hero now, which is ridiculous. I'm just a guy who wanted to store his tools legally and refused to be pushed around by someone abusing their authority. But if my experience encourages other homeowners to question unfair HOA actions and demand accountability, then maybe something good came from all that stress and conflict. The engineer, Robert Chen, called me last month to tell me he had used my case as an example in a presentation about proper foundation design. He said my storage container installation was now his go-to reference for how to do things right. That made me smile. All that careful planning and documentation had been worth it. David Morrison and I still keep in touch. He tells me my case has helped him win arguments for other clients facing similar HOA overreach. Apparently, judges in Virginia are taking HOA abuse more seriously now, partly because of high-profile cases like Brenda Patterson's. Tom Chen, whose father lost his beloved garden gnomes, reached out after Brenda's conviction. His father had passed away in June, still in the memory care facility. Tom thanked me for holding Brenda accountable, even though it came too late for his dad. At least she can't hurt anyone else now, Tom said. That matters. He was right. It did matter. Sarah and I got engaged in December, almost 2 years after the storage container saga began. We're planning a small wedding next spring, probably somewhere far from any HOA-controlled community. We joke about buying a house in the country where the nearest neighbor is a mile away, and there's no one to complain about storage containers or garden gnomes or anything else. But the truth is, I'm not afraid of HOAs anymore. Most of them are run by decent people trying to maintain their communities. The problem isn't the concept of an HOA. It's when power-hungry individuals like Brenda Patterson use their positions to bully and steal from their neighbors. The key is accountability and transparency. HOAs need clear, fair rules applied consistently to everyone. They need financial oversight to prevent embezzlement, and they need homeowners who are willing to speak up when something isn't right. I learned that I'm stronger than I thought. When I first received that violation notice from Brenda, I was terrified. The idea of fighting an HOA seemed impossible. They had lawyers, authority, and the ability to fine me into bankruptcy. But I also had the law on my side, documentation proving I had done everything correctly, and eventually, a community of neighbors who were tired of being pushed around. Together, we were stronger than one corrupt board president. My storage container still sits on that engineered foundation, a gray-blue metal box that holds tools and equipment and memories of a battle that changed my life. Every time I see it when I check on the rental property, I'm reminded that doing the right thing isn't always easy, but it's always worth it. Brenda Patterson is 2 years into her 6-year sentence now. I heard through Marcus that she tried to appeal her conviction, but it was denied. She'll serve at least 4 years before being eligible for parole. I don't wish her suffering, but I do hope she's learned something about the consequences of abusing power and treating people badly. The Maplewood Estates community is thriving under new leadership. Property values are up, community events are well attended, and there's a sense of trust that had been missing during Brenda's tenure. People actually enjoy living there now instead of living in fear of arbitrary violation notices. And me, I'm doing great. My business is successful. My relationship with Sarah is strong, and I've learned valuable lessons about standing up for myself and fighting for what's right. The storage container dispute was the hardest thing I'd ever gone through at the time, but it made me a better, stronger person. Sometimes the fights you don't want to have are the most important ones. Sometimes a storage container is more than just a place to keep your tools. Sometimes it's the line in the sand where you decide you won't be pushed around anymore. I'm glad I fought back. I'm glad I didn't just move the container and accept the injustice. Because in the end, it wasn't just about me. It was about creating a fairer system for everyone in the community and holding a corrupt official accountable for her crimes. That engineer-certified foundation turned out to be the most important foundation of all, not because it held up a storage container, but because it represented doing things the right way, following the rules and standing firm when challenged by someone who thought they were above accountability. And now, finally, everything makes sense again.